All right, I want to read this, and then I want to mention first all the things that stand out uh, for this motion to quash subpoena, deuces, tecum, and for protective order. So they didn't mention an argument for their protective order about my FOIA and how they could have said in their arguments that they already answered my FOIA with their arguments. They did not mention that in here. I'm a little surprised by that. And also, all the public employees court cases that they mention for court cases in here have no involvement with the police. None. Those arguments were in favor for, I don't know, what was it, like a sanitation worker or a water department or something. None of them mention cops. And I think, in my opinion, there should be an exception for cops. So I find it interesting that they make these arguments, and all public employees are protected, and cops who make our criminal records vulnerable to the public. Cops' training records are more protected than criminal records. That is not fair. All right, public employees have different effects upon the public, and cops are some of the most changing of our status in the community. Cops have the most impact on the status of our status in the community. So, a water department worker, what do they do that could change our status in the community from being safe to being in danger? Or even fire departments. The cops are the ones who have the most leverage to change how the community treats us, how the community looks at us, at each other. Cops can create divides amongst people. That doesn't happen at the fire department, water department, or any other of the government organizations. So there should be some kind of exception for cops. Now, and I would argue that none of the criminal case law mentioned in here has any reference to how cops need to be protected, how their records need to be protected from public viewing, reading. They're preventing people from reading the public records. They don't want people reading the special protected information. Like, reading is such a danger. All right, I'm going to read this. All right, the city of Natchitoches, the city respectfully submits this motion to quash subpoena duce tecum and for protective order with incorporated memorandum and support as follows. Background: Travis Hines requested a writ of subpoena duce tecum, the SDT, be issued to the city of Natchitoches, demanding police policies, training, and disciplinary records for Officer Davis, Favors, and Miller. And as a part of the background, they could have mentioned the FOIA, like they completely forgotten about it. Law and argument. The city objects to the SDT because it requests documents, training information prohibited from disclosure under Louisiana law. RS 44 prohibits disclosure of all records and information pertaining to security procedures, investigative training information, or aids, investigative techniques, investigative technical equipment, or instructions on the use thereof, including but not limited to physical security information, proprietary information, operational plans, and the analysis of such information, or internal security information. Louisiana's Attorney General has already expressly stated it is the opinion of this state, and it'd be nice if they mentioned his name, a list of training received by police officers who conduct training, amongst other things, are all protected from disclosure due to RS 443A3. In 2012, the city moves to quash the SDT because the subpoenaed records, disciplinary records, privileged and protected under Louisiana law as they and seek as they what? As they and seek material that implicates an individual's reasonable expectation of privacy. A reasonable expectation of privacy. Like it shows their home address. They don't know how to redact in Louisiana. That's their problem. Louisiana courts have held, we believe, that all public employees that a public employee does have an expectation of privacy in records of all disciplinary actions, reprimands, apologies, and other personal documents. How about awards? Why don't you mention awards too? They're too ashamed to even bring up the awards and how that creates jealousy. They're too ashamed to mention that. And that this expectation is a type which society at large is prepared to recognize as reasonable, because the courts tell society what we're prepared to recognize these days, especially in Louisiana. We find that the trial court did not err in ruling that Goldsman's personal records were exempt from the Public Records Act. And then, I read this case. Don't involve any cops. The city moves to quash the SDD because the subpoenaed records, police records, are vague and no such records exist as written. The SDD is unreasonable as written. Police records? Did I write police records? I thought I wrote police policies. The city moves to quash the SDD as not relevant to the issues. So, learning about or reading. I've researched cops, police policies, and training records in the past. I've even had lawyers recognize public defender say that it is reasonable and it is relevant. So that's your opinion. The Louisiana Code of Civil Procedure states the following regarding subpoenas duces tecum. The court in which the action is pending in its discretion may vacate or modify the subpoena if it is unreasonable or oppressive. Okay, a trial court has broad discretion in discovery matters, including the right to refuse or limit discovery of matters that are not relevant to the issues. All right, I have to read Johnson v. Louisiana Department of Labor. Louisiana law and administrative guidance have applied the provisions of 44.3 specifically in the context of quashing or denying access to documents in relation to subpoenas duce tecum. Okay. Canella v. Johnson. This is another one. This was not meant. This might not have been mentioned in my FOIA. The city further requests a protective order. A protective order may issue and discovery may be limited to protect a party or persons from annoyance, embarrassment, oppression, or undue burden or expense. How about, once again, they're leaning towards the embarrassment angle, when the courts have also mentioned that winning awards can create jealousy. So how about mentioning the jealousy part? How convenient. How convenient. They love to argue how the aspects of public records cause embarrassment, but no mention of the other side of causing jealousy. How convenient. The city is entitled to an order quashing the writ of subpoena duce tecum. Further, the city requests a protective order protecting the city from inquiries into the multiple topics which are privileged. Privileged. How do the people feel about this? It seems like they have accepted that. Wherefore, the city of Natchitoches respectfully prays that the court grant this motion quashing the writ of subpoena duce tecum, protecting the city of Natchitoches from the inquiries into the topics identified in the writ of subpoena duce tecum. And then that's them guys. Morgan Briggs, I guess, is the main writer. Joshua Dara wrote for the FOIA. Maybe that's why Briggs didn't mention the FOIA, because Joshua Dara didn't tell him. He didn't tell him about that, because that would have probably been a good argument to put in here too. Certificate of service. I hereby certify that a copy of the above and foregoing motion to quash subpoena Deus Tecum and for protective order with incorporated memorandum and support has been served upon me. Out of Alexandria, that's Morgan again. And then I find this interesting. I mean, this has nothing, absolutely nothing to do with my DA. These guys are going at rogue. The city has like not turned to the DA on this, or have they? Rule to show cause. Now this is what they wrote for Judge Owsley. Upon consideration of the motion to quash subpoena Deus Tecum and for protective order with incorporated memorandum and support of Natchitoches in the above reference matter, hereby ordered and adjudged and decreed Travis Hines appear. I think he wrote the order. They probably didn't even give him an order, because this is his writing for sure. He's been doing this for all of my motions. To show cause why the city of Natchitoches should not be granted the writ of subpoena Deus Tecum issued by Travis Hines should not be quashed and protective order should not be granted. Okay, and look at this. Now, 10th Judicial District Court. He's a city judge. See, it's like this is his type of writing, but I have to look at his title again. I thought that he was a city judge, and I guess that's his signature. I'm not sure. But I mean, they stamped it. So yeah, that's it, and it's kind of messed up. It doesn't. Cops need an exception to this for sure.